Has begun, we of course ask that everyone please refrain from taking photographs so as to not distract the oralists. Also, please refrain from any applause until after all 4 oralists have been heard and the judges have retired to their chambers. After the judges deliberate, the session will be reconvened and the judges will announce their decision as to best brief, best team overall, and best oralist for tonight. And finally, the Board of Student Advisors would like to remind everyone and to invite those who are here for the first time that there will be a reception following the argument over in John Shipman Gray Room in Pound Hall for everyone who is in the courtroom this evening. Thank you very much. The judges will be out in a few moments.
The court is now sitting. God save this country and this honorable court. All rise.
I think that's enough. We'll hear argument this evening in Reed Corporation and Norport Industries. Mr. Patton, whenever you are ready to proceed.
May it please the Court. Good evening, Your Honors. Chief Justice Souter, members of the Court. My name is David Patton. Co-counsel Jeff Rosenthal and I represent the petitioner, Reed Corporation. This case concerns the extent of successor and parent corporation liability under the Comprehensive Environmental Response Compensation and Liability Act, otherwise known as CERCLA. I will argue that this Court should defer to the EPA's interpretation of successor and parent liability as contained in the EPA guidance document. Co-counsel will argue that if this Court does not defer to the EPA, that CERCLA requires expansive rules of successor and parent liability. Your Honors, we have reserved 4 minutes for rebuttal. Reed seeks contribution from Respondent Norport for hazardous waste cleanup costs at Reed's Amesville facility. Reed claims that Norport is liable as the parent of EPTEC Corporation. EPTEC is the successor to Thompson, which generated and disposed of hazardous waste at Reed's facility. Reed claims that Norport is liable because Thompson dissolved after being purchased by EPTEC and because EPTEC is now unable to pay due to previously existing environmental liabilities which far outstrip its assets. Your Honors, in deciding the rule of successor and parent liability in this case, this Court need look no further than the EPA guidance document. The EPA, pursuant to its administering authority as the administering agency of CERCLA.
Let me ask you a question about this assertion of yours that we should give deference to the legal determination made by the administrative agency. Shouldn't it be the case that, or is a precondition to that kind of deference, that the Congress have made the policy choice to let the administrative agency make the choice?
Your Honor, this Court's jurisprudence, beginning first in Chevron, holds that when Congress has not spoken to the precise question at issue, in other words, when it has left an ambiguous wording in the statute or it has left a gap, this court must defer to the administering agency, which in this case is the EPA. Congress implicitly delegated to the EPA authority to interpret the word corporation as...
Counsel, I see nothing in that statute that delegates under Section 107, and indeed, even if I were to give you that we apply Chevron, if the statute speaks, we don't go further. It is arguable that Section 107 specifically speaks to whether there's successor liability of a generator. We have a discussion of previous owners in the statute on operators, but not on generators.
Your Honor, that seems to implicate two questions. The first is the general delegation to the EPA. Now, the EPA is the administering authority of CERCLA, and under Sections 9604 and 9606, it has the power to issue both reimbursement orders to parties, potentially liable parties, and cleanup orders to potentially liable parties. And under Section 9606, this court must defer to any EPA order. Now, for the EPA to determine who may be liable, it must have some authority to promulgate guidance documents such as this case in order to determine which parties may be liable. That is why Congress implicitly delegated, Your Honor.
How can you say that the determination of who is liable is mere guidance?
Your Honor, the term guidance document is merely a term of art. The EPA has promulgated the document giving its interpretation of the statute. Now, when the EPA interprets the statute, as this court said in Food Workers, when an agency interprets the statute, when Congress has not spoken to the direct question at issue, and the question in this case is the extent of successor and parent corporation liability,
yes,
which successors and which parents are liable.
But we have simply the question of what does the word corporation mean. That strikes me as a purely legal question. And if it is to be a legal question that's taken from the courts, shouldn't we insist that the Congress do so by a clear statement?
Well, Your Honor, it is not merely a legal question. The question of defining corporation as it applies to successor and parent liability involves policy issues and giving content to the terms of the statute, which, I'm sorry,
only
Your Honor.
in the sense that every interpretation of a statutory measure by the Congress contains some policy consequences. But shouldn't we, as we do in other questions of invasion of states' rights, insist on a clear statement and not rely upon ambiguity as an implied grant of authority from the Article III adjudicator to an administrative agency?
Well, Your Honor, this court's jurisprudence in Chevron does not say that there must be an explicit grant from Congress. A mere ambiguity or gap in the statute is sufficient when you have an administering agency, and that is exactly what is the case here, in this case, Your Honor.
If the EPA had simply issued what you referred to as a reimbursement order, and we had an issue before us which was basically a contest between the EPA and Norport, would we be obliged to give any deference to the fact that the EPA had taken a position?
Under Section 9606, Your Honor, when the EPA does issue an order to clean up to a party and has compiled an administrative record, this court owes great deference to that order, to the standard that the EPA's order is not arbitrary or capricious or manifestly contradictory to the statute, despite the fact that the EPA has not gone through any judicial proceeding to get that order. If the EPA issues the order, this court must defer. And for the EPA to have the authority, the ability to determine liable parties, it must be able to say which parties may be liable, which in this case is Norport Industries, Your Honor.
Then why don't we simply wait for the EPA to act and give them the deference then?
Your Honor, the problem with that is the right of contribution under Section 9613 seeks to encourage private parties, such as Reed, to undertake cleanup efforts themselves and then seek contribution from other parties. Now, if this court or if this country had to wait for the EPA to act in every situation where there was a hazardous waste spill, hazardous waste would not be cleaned up quickly, and that is one of the major goals of CERCLA. So by allowing the right of contribution and then allowing this court to defer to an agency interpretation, that best effectuates the goals of CERCLA, Your Honor. Now, as to the question of states' rights and whether state law should apply in this case, CERCLA manifests a rather strong intent, as a matter of fact, a definitive intent, that state liability rules should not govern. One of the main reasons why CERCLA was enacted was that the so-called laboratory of the states, as trumpeted by Norport, created such a big hazardous waste mess that the Congress felt the need to enact CERCLA and to move the states out of liability actions.
But presumably the problems of contribution didn't create the hazardous waste mess.
No, Your Honor, but the question raised by Justice Higginbotham regarded states' rights and whether we should allow state liability rules to apply in this situation, and Congress was rather clear that that should not be the case. To the extent that any state liability rule contradicts CERCLA, it is overridden. The states only have the authority to pass liability rules that are actually broader than CERCLA. So CERCLA sets the floor, and CERCLA does not allow any state laws to take effect. Furthermore, under this court's decision in Choctaw Indians versus Holyfield, there was a presumption that a federal statute must be applied uniformly and that Congress does not wish the definition of key terms in a statute. In that case, the question was the definition of domicile under the Indian Child Welfare Act. In this case, it's the question of corporation. Congress does not want the definition of those terms to be subject to state law, especially in a case where uniformity is essential. And given the interstate nature of hazardous waste, Your Honor—
Counsel, it's my recollection of some of the discussion in the Federalist Papers that uniformity and ease of administration hardly make a federal system. It seems to me that the argument for federal law falls on its face if your only argument is uniformity and ease of administration.
That is not the totality of our argument. However, we must take into account the specific factors of each case and what Congress's intent was. Now, when Congress says state liability rules won't apply, that's a strong indication that Congress was not happy with the way the states were administering hazardous waste cleanup.
But if you argue that we're interpreting an ambiguous term in a statute, corporation, the only law we have is the law that creates the corporation, the state.
That is not true, Your Honor. In this case, you have the EPA, which has promulgated the guidance document, and that is exactly what administering agencies are supposed to do in the modern administrative state. Somebody must decide what the rule is going to be in this case, and the courts have decided, starting in Chevron and continuing through Rust versus Sullivan, that the administrative agency is in the best position to do that. They are better able to infer congressional intent.
What does the EPA know about corporate law?
Well, that is another confusion that Norport injects into this controversy, Your Honor. The question here is not a question of corporate law, a question of the existence and status of the corporation. It's a question of hazardous waste liability, which happens to involve a corporation.
Do you think that the purchasers of corporations who decide who to purchase and who don't purchase are looking to the EPA to decide what their liabilities are?
No, Your Honor, but that's not relevant to the question at hand. The purchasers of corporations back in the 1960s weren't looking to anybody, but a lot of those corporations are being held liable under CERCLA because CERCLA's liability provisions are retroactive. Now, in this case, Your Honor, as to the question of the EPA and expertise in corporate law. Again, the question is of successor and parent liability and which corporations should be liable. And again, the EPA has explicit delegation from Congress under 9604 and 9606 to decide which parties should be liable. Furthermore, the only cases cited by Norport, those being Kamen versus Kemper and Burks versus Lasker, deal with internal corporate disputes, such as a shareholder derivative suit. Now, there are two major differences between those kinds of cases and the kind of case that we have here, Your Honor. One is effect. In those cases, no matter what rule of law comes from this court, the only parties that are affected are the shareholders and the board of directors. Nobody outside the corporation is affected.
Well, you mean you were only going to ignore the insulation that's normally attendant to corporate status with this little $135 million liability, but otherwise everything's okay?
No, Your Honor, that's not the point. The point is that the
point is that this is utterly devastating to these companies in terms of the level of liability that's being imposed, and what you're doing is you're setting aside the commercial expectations of those companies, aren't you?
Your Honor, CERCLA set aside many commercial expectations by imposing retroactive liability on corporations.
Yes, but
also, Your Honor, I'm sorry.
CERCLA did, which is to say the Congress did.
Yes.
But now you're asking us by implication to expand that.
Your Honor, there's no reason to believe that if Congress wanted retroactive application, as a matter of fact, it wasn't Congress itself, it was the courts that imposed retroactive application of CERCLA liability, and then Congress approved. But there's no reason to believe that if Congress didn't want corporations in general to be liable, that it wouldn't want parents liable if they're liable anyway under CERCLA.
Well, counsel, lots of statutes. Congress does know about successor and parent corporations, and lots of statutes have specifically made liable parent and successor corporations. They did not do so here, and in the case of operators of the dumps, they talked about previous owners, and they didn't with respect to generators.
That may be true, Your Honor, but as in our brief, as we pointed out, that analogizing from other statutes to see what another statute did in terms of liability is not very helpful. But if we look to two other cases, that being Golden State versus NLRB and Owner 2 versus US EPA, especially in Owner 2, where Judge, who is now Justice Kennedy, deferred to the EPA interpretation of parent liability despite no delegation from Congress and despite only a general grant of authority to the EPA to administer the statute. That case is very factually similar to this case, yet the judge in that case did defer to the EPA.
And to what extent does your argument rely upon a need for uniformity in the assertion that a reference to state law would not serve the purposes of the uniformity, but rather would frustrate the purposes for lack of it?
Your Honor, one of the main problems is that state laws differ in terms of the extent to which they impose liability on corporations and on successors and parents. Now, as this court noted in Choctaw Indians, when you have a difference in terms, one state may define domicile differently. In this case, one state may hold a parent liable and another state may not. All the corporations may do is either move to different states or that they can arrange their commercial arrangements to evade liability.
But I read your argument not to strike for uniformity, but to contend for a different form of liability.
Well, Your Honor, there needs to be both. There needs to be both expansive rules, which co-counsel will argue for, and uniformity. Again, the presumption is that Congress intended CERCLA to be enacted uniformly unless it gave a manifest indication to the contrary. That is this Court's pronouncement in Choctaw Indians. That is this Court's pronouncement in NLRB versus Hearst Industries. That is what this Court must assume to begin with, Your Honor.
But the Congress was very specific in the case of the NLRB and the application of the National Labor Relations Act that would, in fact, be some national uniformity. Congress has not spoken in this statute.
Well, that's not true, Your Honor. It actually has spoken, especially in terms of liability. And again, that is in the provision that says that to the extent that any state liability provision contradicts or conflicts with CERCLA, it is expressly overridden. Congress does not want different standards to apply depending on what state one is in, especially given...
But you define a conflict with the federal policy as being any statute which stands as a barrier to liability.
Yes, Your Honor.
Well, it seems to me that renders your whole argument tautological. The purposes of the statute are to reach the parties that are responsible, and we're going to redefine that anyone that has a deep pocket is going to be responsible.
Well, Your Honor, that may go to the question of whether Norport will be ultimately liable. But as to the question of uniformity, when Congress spoke, it did not specifically include state liability laws, and it, again, expressly stated state liability rules are overridden. Congress had to set a uniform standard.
Let's accept your premise. We would have uniformity, and state liability rules would be overridden. If we simply adopted the position that in the absence of any congressional act, there will be no successor or parent liability, and number two, that any state law which would purport to require a different result will be overridden.
Well, Your Honor, that would
achieves both, doesn't it?
That would flatly contradict Congress's desire to impose broad liability and to make sure that corporations pay for the cost of their hazardous waste, not the taxpayer. Now, co-counsel will be better able to explain why the expansive rules are better than no rule at all, but it certainly can't be true that Congress didn't want any successors or any parents liable, because it would have completely gutted CERCLA. Any corporation that dumped would merely need to spin off a subsidiary or sell its asset to somebody else, and then the taxpayers would be stuck with a bill. And that is clearly not what Congress wanted.
Your time is up. The red light is on.
Oh, I'm sorry. I'm sorry. I see that our red light doesn't go on, and I don't see any lights on. I see my time's expired. Thank you, Your Honors.
All lights on and take the time's up. It's 2 minutes over.
Oh, I don't have a label on mine. He's got 2 minutes more? The court's face is red. You have time for 2 more minutes of that sentence, Mr. Patton.
I'll see if I can keep the sentence going, Your Honor.
Having embarrassed the court, go ahead.
I'm sorry.
Well, I'd like to just follow up on where you were.
Yes, Your Honor.
If we accept your argument for uniformity, it's my understanding that 42 out of what we have now 50 states have roughly the same rules with respect to the traditional rules for parent and successor liability. Even if we go with uniformity by adopting state law, we pretty much get it.
Well, that is not true, Your Honor. The fact that there are any states which have different rules makes it impossible to fairly and efficiently administer CERCLA unless there is one rule. The fact that in California...
Efficient administration is not the argument. The argument is over who is liable under a definition of corporation. If we have rough uniformity among the states, shouldn't that be where we turn?
Your Honor, that is not Congress's intent, as we have stated several times, and that is not this Court's presumption. This Court is going to presume that under a federal statute, especially when Reed is bringing a right of contribution action, an express right of contribution action under that federal statute, when Congress has mandated specific liability rules and Congress has delegated to the EPA, let us not forget the first place this Court must turn. We don't even look at the question of uniformity until we decide whether to defer to the EPA. Now, the EPA has the authority to administer CERCLA. The EPA has promulgated the guidance document. document. And as long as this court believes that that interpretation is permissible, it must defer, even if you would choose, Your Honors, a different rule of liability for Norport in this case. Because the EPA, again, is the agency. It's been entrusted by Congress to administer CERCLA, and it has broad authority to administer the statute. If there are no more questions, Your Honor, I'm not going to press my luck this time. Thank you.
Thank you, Mr. Patton. Mr. Rosenthal?
May it please the Court. Your Honors, my name is Jeff Rosenthal. I represent Petitioner Reed Corporation and will argue that CERCLA requires uniform, expansive rules of successor and parent liability. The substantial continuity test and significant benefit test further CERCLA's important goals of preventing hazardous waste contamination.
Let me ask you about uniformity. Do you have any idea about how many states, state law would actually support the theory that you put forward to reach this parent corporation, namely that all that's necessary is that there be some benefit and that the sub not be able to pay?
Your Honor, very few states have, as Mr. Patton mentioned, diverged from the traditional test of parent and successor liability.
Have any?
Some states, such as New Jersey and California, have enacted standards that are similar, if not exactly like the test that's proposed by Reed Corporation.
Well, the fact is you can't reach the result that you contend for by reference to state law. So it's not uniformity that's really the barrier, is it? It's the fact that the law itself stands against you.
Your Honor, there needs to be both uniformity, and it's important to remember that this court must interpret an ambiguous provision consistent with Congress's policy goals in enacting the statute. And the traditional rules advocated by Norport fail to do so because they do not encourage prevention of hazardous waste, they do not encourage the monitoring of hazardous waste activities.
But if the normal repository of law that defines corporations is a state, and at the time the Congress passes the statute, virtually none of those states recognize the definition of corporation, which will embrace the corporate successor, the parent subsidiary liability you contend for. Why shouldn't we conclude exactly the opposite of what you contend, that Congress intended no such thing?
Your Honor, first of all, this court noted in Hearst versus NLRB that the court should not look to traditional notions, but must instead look to the purposes of the statute and ensure that any traditional notions to be adopted must be consistent with the purpose of the statute. Now, only an expansive test of liability will actually encourage the prevention of hazardous waste.
Let me ask you about that. Let's take the case of you're going from congressional intent to a policy that would effect it. And let me ask you about your policy premise in the case of the successor liability to one who purchases assets. And take this case as an example. What could the purchaser of assets, as a practical matter, in this case have done to assure his corporation that he was not walking into successor liability if you win?
Your Honor, a corporation, when it buys the stock of another corporation, has ways of due diligence to ensure that it is not taking on any massive liabilities that are unexpected. Similarly, when the corporation were
So in this case, they would say, who disposes of your hazardous waste for you, right?
Well, the difference in this case...
Well, isn't that right?
In the normal successor context, yes.
And they would be told that Reed did it, didn't they? Wouldn't they?
They would see.
And how could they find out whether Reed was likely to have violated the standards for hazardous waste disposal?
Well, Your Honor, they would conduct the same environmental audit that they would conduct if there were a statutory merger.
You mean they would go to Reed's property and start boring into the ground?
They might conduct some inquiry. They might ask Thompson Industries to provide some kind of indication that Reed is a good facility or that Reed does take special care.
I mean, literally, how could, I want to get down to concrete cases. How could they do it without either, on the one hand, just contenting themselves with a series of meaningless questions, or on the other hand, getting down there doing soil borings, which you know perfectly well they couldn't do?
Your Honor, I don't know exactly how they would do it, but I do know...
Well, don't you think we ought to know how they would do it before we premise liability on your policy argument?
No, that's not true, Your Honor, because in the...
We don't have to, we don't care?
No, well, in the statutory merger context, Your Honor, this inquiry is possible. And we know that statutory mergers are not...
The inquiry is possible, but how do they answer it?
I don't know exactly how they do the inquiry, but it is possible in the merger context. Therefore, it must clearly also be possible in the asset
They'll
purchase
figure out a way? Is that what we should rest our decision on?
Well, the experts are already doing it. When they purchase stock, when they merged under a statute, they are already doing it. And as studies have shown, it is not chilling mergers, the prospect of circular liability. We need to look at what will happen in a situation under the traditional test and what will happen under expansive tests. Under expansive tests, when predecessor corporations know that potential successor corporations are going to require some proof of safe hazardous waste disposal activities, they will do the safest methods and they will make sure to document it. However,
But aren't you ultimately saying that the parent will, under your rule, be liable for the debt of this liability of the subsidiary if, in fact, there's not any benefit that's flowing and the sub simply can't respond to that level of liability? No more is required under your theory, is that correct?
either a significant benefit or a capacity to control and the sub's inability to pay. That's correct, Your Honor.
I have some trouble with locating some principled limit or some defining principle to that. For example, what would be your position with regard to a creditor or a supplier? They would be conferring a benefit, and if the recipient could not respond financially, those principles are met. Would you?
Your Honor, first limiting principle to note in the guidance document is that it must be a parent corporation. And Norport here is, for sure, the parent corporation of EPTEC. That's one limiting principle. Secondly, a limiting principle is in the substantial benefit that
Well, but
the
counsel, as I read this record, these are all, the transactions between Norport and EPTEC are all arm's length transactions. So how does that distinguish? There is no fraud. There is no borrowing back and forth. None of the traditional concerns
That's
that we
correct,
worry
Your Honor.
about in liability. So what is different from that than any other electronics supplier out there who also benefits Norport and who also provides all those things?
Your Honor, the benefit that Norport receives in owning a subsidiary that loses money every single year is that the corporation has its hazardous waste producing activities and its circuit board manufacturing sheltered in a subsidiary. Were Norport to have to do that business itself and not be able to shelter it in a money-losing subsidiary, Norport would clearly be liable. Furthermore, were EPTEC to be fully capitalized, Norport, contrary to their argument, would be paying, because for every dollar of lost profits that Norport would suffer by EPTEC's liabilities, Norport would lose that same dollar.
And by that same argument, if Congress really intended this test that you put forth, then Congress also intended that merger not occur. Because if Norport had known that it was taking on this additional liability plus a losing corporation, the merger never would have occurred.
And, Your Honor, in situations in which companies are creating more hazardous waste liabilities than good to society that they're producing, these companies should not be in business. Furthermore, Congress would not have necessarily preempted a transaction like this, in that this transaction occurred before CERCLA was enacted. And CERCLA is applied retroactively because the primary goal of CERCLA is to clean up the environment and to look at all the past hazardous waste contaminations and find somebody to pay for the cost of cleanup and not the taxpayer. The Superfund right now is extremely overburdened, and therefore Congress intended broad liability provisions to include everybody that somehow benefited from the hazardous waste.
Well, let me, if I may, go back to your parent liability test or twin test of control and benefit. As a practical matter, wouldn't it be simpler to say that the parent is always going to be liable?
Your Honor, in most situations, the
come out and say
parent
that?
corporation would be liable.
The only case in which it wouldn't be would be the case in which the parent corporation was so incompetently managed that it in fact did not have control and didn't basically get a dime's worth out of benefit from the relationship. And you assume that there could be such cases, right?
Your Honor, the important thing...
Is that correct? Do you assume there could be such cases?
I wouldn't imagine there would be very many corporations out there like that. However, there is another scenario.
But if there were such a corporation, then on your theory, the only instance in which there would not be parent corporation liability would be the instance in which the parent basically had totally lost control and got no benefit, and you would therefore be rewarding the incompetent parent for the very reason that it didn't control and didn't force its subsidiary corporation to stay clean.
No, Your Honor, I disagree. The control provision in the EPA guidance document is a capacity to control. And as long as that parent has the capacity to control the subsidiary, whether it does or doesn't...
Then we're back with the first alternative, that by definition, the parent is always going to be liable.
A parent will almost always be liable under this test, Your Honor. However, it's important to look at what the practical
Then why
results
don't,
will be.
if you want us to adopt a test, why don't you simply say, adopt the test that the parent is liable and skip the business about control and benefit?
Because this allows a corporation that didn't have any capacity to control. I could think of a situation in which they might not, which might be in which if the New York Times owned EPTEC in this situation, the New York Times might not have any expertise or any knowledge about circuit board production or hazardous waste activities and might really not have the capacity to control a company.
Well, what do you mean by capacity control? You mean the expertness in a subject matter, or do you mean, are you referring to a corporate relationship? I guess I assumed you were referring to a corporate relationship.
Your Honor, that's something for the district court to consider.
Well, no, it's something for us to consider because you want us to adopt a test, and I'm not sure what the test is supposed to mean. Does it refer to corporate capacity to control or something else?
Your Honor, it looks at corporate capacity to control, and however...
Then the parent always is going to be liable.
Then in that case, if the court finds that, the parent would always be liable. However, the practical effects...
Well, then, because the Congress didn't say that, didn't say parent and didn't say successor, but said corporation, why shouldn't we just stop at that point and let the Congress do its job?
Because
if they want to, all they've got to do is to pass an amendment which says, it amends that statute and says parent and includes successor liability.
Because, Your Honor, this court must interpret corporation in some way that's consistent with the purposes of CERCLA. And CERCLA imposes broad liability provisions. It imposes it jointly and severably. Liability is strict. It's imposed retroactively. And it's not limited to parties that actually contaminate the environment, but includes generators, transporters, and disposers who dump in a dump site that's later discovered to be contaminated by another party. And CERCLA does that and has that scheme because it desires the taxpayer to pay as a last resort, and those who benefit pay for the cost of cleanup. In this case, Norport benefits because Norport's hazardous waste producing activities are sheltered through its subsidiary, and EPTEC benefited because, as the court in Smithland noted, any cutting corners or prevention costs that the predecessor corporation failed to take are savings that are realized by the successor corporation.
Do you see any due process limitations to the contentions that you are making?
No, Your Honor. As courts that have adjudicated the retroactivity provisions of CERCLA have noted, there is no due process problem with causing those companies that have polluted the environment with cleaning it up.
Is there no due process limit to the how Congress can allocate that liability?
No, Your Honor, there isn't. As this court noted, for example, in Golden State Bottling, successor liability under a substantial continuity test is appropriate in a situation in which to fail to hold the successor liable would frustrate the purposes of the statute. Now, that's been extended to CERCLA by not only the district court in this case, but the court in Mexico Feed and Seed, and also in other contexts such as Title VII, Section 1981.
Counsel, I fail to see why there's a frustration of the purpose when presumably the state interest and the federal interest are exactly the same. Both want to clean up. So to turn our definition towards state law does not necessarily frustrate the purpose. Indeed, they are complementary purposes.
Your Honor, were the states doing an adequate job, there would have been no need to pass CERCLA. However, as Congress specifically noted that CERCLA was required because states were failing to clean up the environment. Furthermore, even after many of the
Congress did another thing to help out the states. They created the Superfund.
Yes, they did, and the Superfund is meant only as a last resort when there are no solvent liable parties to clean up the environment. And Superfund is extremely
Which begs the question.
Your Honor, Superfund is really...
Doesn't it? I mean, that doesn't get us anywhere.
Your Honor, but
we want to know who's liable.
But Congress further held in 1986, after all the states passed their mini Superfund, or many states passed mini Superfund statutes or mini CERCLA statutes, that states were still failing to give plaintiffs their day in court. And therefore, Congress endorsed right of contribution. And the Superfund in itself is not...
Oh, the legislative history of that part of the statute is pretty clear. They were worried about statutes of limitations, and they were worried about a national service of process, all the things that just sort of get you in and out of court, not who's liable.
But Congress also added a right of contribution to ensure that parties are encouraged to clean up the environment as quickly as possible, and therefore telling these parties that they can go out and seek out other liable parties and get some kind of recovery. It's important to remember also that in situations in which parents and successors would be liable, a rule of successor and parent liability wouldn't always hold them completely liable. What that would do is it would allow the district court to take into account equitable factors in a contribution action under 9613, and it gives the district court flexibility to determine.
What would those equitable factors be? Who has the deepest pocket?
Equitable factors would be who might have caused the contamination, who failed to take certain due care, what parties might be closest in terms of the ability to clean up the environment, whatever factors that the district court feels are equitable in imposing liability. And in those situations, Norport, in this case, will be able to go back to the district court and argue the equitableness of holding it liable versus holding Reed liable. Reed only asks this court to impose a doctrine of successor and liability that gives the district court those powers to do it on a case-by-case basis. That is completely consistent with CERCLA in that joint and several liability is not absolute, but is meant to give district courts flexibility. I see that my time has expired, and if there are no further questions, I'd like to thank you and ask you to reverse the decision of the Court of Appeals.
Thank you, Mr. Rosenthal. Mr. Mirren?
Mr. Chief Justice, and may it please the Court. My name is Daniel Meron, and along with my co-counsel Jeffrey Dean, I represent the respondent, Norport Industries. I will argue that state law rather than federal law controls when one corporation is derivatively liable for another corporation's CERCLA liabilities. My co-counsel will argue that assuming federal law controls that issue, the courts below are not required to defer to the EPA's reconstruction of CERCLA's liability provisions, and that at any rate, CERCLA does not require as a matter of law expansive notions of derivative corporate liability. It would perhaps be useful to begin by clarifying what is not at issue in this case. The question in this case is not whether a federal court has authority to construe a federal statute. Of course it does. Nor is the issue in this case whether hazardous waste sites ought to be cleaned up. Of course they should. Instead, the question in this case concerns federalism, and specifically whether CERCLA authorizes, much less requires, this court, by judicial fiat, to create expansive notions of derivative corporate liability, when to do so would mean sweeping aside the considered judgments of every state in this union. I will be making two main arguments. First, I will argue that this court does not have the authority to create an additional category of liability that Congress itself did not impose. Second, I will argue that even assuming this court had that authority, it should borrow state law as the appropriate rule of decision. It goes without saying that this court has the authority to construe CERCLA's existing liability provisions and to determine who does and who does not fall within their terms. Reed characters our position in its reply brief when it asserts that we would deny this court that power. But this is not a case of statutory construction for the simple reason that there is no provision to construe. As all 5 circuit courts to have considered this question have agreed, that is
nothing to construe. The difficulty is that the word corporation has no meaning independent of context. The word has meaning and pulled out of some kind of a legal matrix. That it's a corporation, and what all that attends a corporation, what's necessary to maintain it. You've got to look somewhere, in other words, to define the principle. There inevitably is a choice of law question, isn't there?
Well, Your Honor, in fact, what we think is the only meaning, we agree with you, the only meaning that the word corporation has is what state law says it is.
Well, Counselor, unless I don't remember very well what Professor Miller taught me in civil procedure, you look to state law in diversity jurisdiction. You will concede that this is a federal statute, will you not?
Certainly, Your Honor.
You will concede we are in federal question jurisdiction.
Certainly.
Once having conceded that, where is the authority to look to state law?
Your Honor, the authority consists of the fact, arises rather from the fact that federal law is silent. Our argument is this: the federal statute itself does not impose derivative corporate liability. Second, federal common law does not, because this court does not have the authority to create an additional category of liability. That, however, does not mean that state law cannot provide a remedy here. Now, the word corporation does appear in the statute. It appears one place. It appears as one of the definitions to the word person in the definitional section of CERCLA. But CERCLA's definitional section does not create liabilities. The only provision in CERCLA that makes generators liable is section 107A3. Now, that section provides as follows. every person who arranges for the disposal of waste at a facility is liable for the cleanup of that facility. Now, even substituting the word corporation for the word person, the question would be, what does it mean to be the corporation who arranges? Now, when you have one corporation, in this case Thompson, that disposes of waste at a facility, and then some years later another corporation purchases assets from that first corporation, it is implausible to view that second corporation as being the, quote, corporation who arranged for disposal. Reed does not allege for, in this case, that Norport is the corporation who arranged for disposal, and that ends the matter as to federal statute. We are not liable under the statute.
I suppose there's a contention that there's a partnership or a joint venture. What law would we look to?
I'm sorry, I didn't hear your question.
Suppose there's a contention that in a multi-state operation, there's a loosely knit organization, that there's in fact a partnership or a joint venture. What law do we look to define those entities?
Well, the presumption, Your Honor, is that when Congress uses a concept that's traditionally a state law concept, for example, corporation, that this court will look to state law. In Burks v. Lasker, this court held unanimously that when the questions of corporate law arise under a statute, the presumption is that unless Congress makes it very clear, it will turn to state law.
The corporation, we have a formal act. We know a place of incorporation, so we have a defined reference point. But with certain relationships, such as joint ventures and consortiums, some of these other concepts, that's a legal result. And my question is, what do we do with the choice of law problem there? I come back to the question that must we not make a choice here as to the law that we're going to apply? Inevitably, I think you seem to be suggesting, as I understand it, that we have no choice to make. Congress has made it, and it is, quote, the state law. I'm saying if we look at the same statute, we don't have a natural reference point for these other entities, do we?
The question of choice of law is different from the question of whether this court has the authority. The question of which law applies, that is a federal question. But to ask the question is not to answer it. And the fact is that Congress itself is not provided here for derivative corporate liability, and if this court were to create that standard, it could do so only as a matter of federal common law. So the question is this: does this court have the authority to create, as a matter of federal common law, derivative corporate liability? And the answer to that question is no, it does not. This court does not sit as a super legislature with the authority to revise federal statutes in order to address general social evils.
Congress, we're not a legislature when all we're doing is trying to bring into fruition the intent of Congress, which, as appellants have said, is this broad liability, which apparently doesn't seem to have any limits on it in terms of who was at fault, and simply is a risk-sharing statute.
Well, in fact, Congress has specified precisely who are the four liable classes of parties under CERCLA, and by all concession, Norport is not one of those parties. Now, this court held squarely in Northwest Airlines and in Radcliffe, two unanimous cases in 1981, that no matter how strong the policy considerations in favor of a certain result is, this court does not have the authority to create new rules or provide new remedies that Congress itself has not created. So if this court were to create federal standards of derivative corporate liability...
Well, that rather begs the question, though, doesn't it? We don't claim that authority. The question is what has the Congress done here? Has the Congress, by setting this, defining this term as, leaving the term corporation undefined, in effect, said to the courts, define it?
But, Your Honor, the question in this case is not...
Surely the answer to that is yes.
Your Honor, the question in this case is not what is a corporation. Norport fully concedes that it is a corporation. The question in this case, what does it mean to be the corporation who arranges for the disposal of waste? And the task in that case is for this court not to speculate in the abstract as to what the word corporation means, but to ask in a common sense way, is it plausible to view Norport here as a, quote, corporation who arranged for the disposal of waste? 5 circuits have considered this question. 5 circuits have said at least this much, and that is that the statutory term cannot possibly enclose within it someone in Norport's status, and that if federal law does create derivative corporate liability, it does so only as a matter of federal common law.
Well, in fact, in the legislative history of CERCLA, the sponsor of the bill, it's my understanding, said we're going to leave some of these definitions to the court. And my recollection is that was Congressman Florio, and he said we're going to let them develop federal common law.
Your Honor, what Representative Florio said was that they would leave to the court to determine standards of joint and several liability. That is, it's clearly within the court's authority to look at the existing parties that are made liable by the statute and to determine rules, to create rules as to how to allocate damages among those parties. There's no question that this court has the authority to do that. The question is this: does it have the authority to create an additional category of liability where Congress itself has not created any? And the answer to that question is no. This court held, even if this case were simply a question of interstitial lawmaking, which it is not, this case would still be a relatively easy case. This court held unanimously just last year in Kamen versus Kemper Financial Services that the court's limited interstitial mandate does not extend to adopting rules whose effect would be to effect a legal reform upon the states. In Kemper Financial Services, Kemper asked this court to adopt as a standard for reviewing demands made on a board the standards adopted by the ALI and its principles of corporate governance. Those standards would have severed the review of demands made on the board from the review of other board actions. This court held that no matter how strong the policy in favor of that legal reform were, it would, quote, exceed the interstitial lawmaking authority of this court to engage in that kind of legal reform. Yet, the rules that Reed asked this court to adopt here, especially the rule of parent liability, make what Kemper Financial Services asked for last year pale by comparison. Reed is asking this court, as a matter of really judicial lawmaking, to create a rule whose clear effect is to do away entirely with limited liability in this country. Now, it's one thing for Congress, where the democratic process works, to choose that kind of rule, and it is an entirely different thing for this court to do so by judicial lawmaking. For this court to do that, it would have to upset it would have to upset a number of recent precedents, some of them unanimous, which have stated very clearly that this court's authority is very limited. It has the authority to implement existing provisions, to provide, for example, in the interstitial context, a statute of limitations period when Congress has not specified any. But to do what Reed asked this court to do here, to create an additional category of liability that Congress itself has not imposed, that would go well beyond this court's precedents and well beyond this court's authority. Now, it is worthwhile to underscore just how radical Reed's request is here. Because if this court were to satisfy Reed's demand for a uniform federal standard of derivative corporate liability, it would have to do here what in Burks v. Laster it said it would never do, and that is create federal bodies of corporate law out of whole cloth. Reed asked this court to adopt a uniform federal definition of derivative corporate liability, and in giving that rule content to defer to the EPA's guidance document.
Yeah, but nobody's creating general corporate law if we rule for the other side here. All we're doing is creating categories of CERCLA liability, not creating general corporation law.
Well, you would be creating federal concepts of corporate law that, yes, would apply only in the CERCLA context. But what they would do in terms of upsetting...
Unless, indeed, Congress gives some indication by legislation that they should apply elsewhere, but that's the responsibility of Congress. It's not the responsibility of this court.
Your Honor, that was true as well in Kamen versus Financial. It was true as well in Burks v. Lasker. All those cases involved, a federal statute, and the only question was the rule would have applied, yes, only in that statute. But the question is, what would it do to the state interest? If this court were to apply a rule that made shareholders of corporations, and I see no principal distinction here between individual shareholders and parent corporations in Reed's argument, if this court were to do away with limited liability, quote unquote, just for CERCLA liabilities.
But won't this directly confront and frustrate the corporate rather the congressional purpose in this statute by creating the incentive of large corporations to utilize subsidiaries incorporated in the states with a law that provides them the greatest insulation, and utilizing those entities for the enterprise that in any way touch hazardous waste businesses?
Your Honor, I believe it would not, and the reason it would not is that has to do with the choice of law problem, not choice of law that is federal.
A corporate lawyer that wouldn't counsel to the contrary, and then when he set out on this enterprise that Justice Souter pursued earlier with counsel opposite to try to find out what the liability was, when he ran into that kind of indeterminacy or these kinds of problems, the first thing he's going to do is try to insulate liability, isn't he?
Your Honor, the question is what law would apply, assuming this court said that state law would apply. Now, under most choice of law principles, we agree with Reed that the choice of law that would apply would be the place of wrong, and that is almost universally understood as a place of injury. So the rule, the prospect that you suggested of a state relocating in a state of which had liberal corporation laws is not realistic, because that in no way would shield liability. The liability that would apply would be the liability of the place of wrong, and that state has no interest in creating standards that would shield a corporation from liability, precisely because no state wants to have contaminated drinking water or an unclean environment, or to be saddled with those kind of problems.
That rests on the premise that the state's determination and resolve with regard to hazardous waste is adequate. And the whole premise of this legislation, I suppose, is that it is not. We do have the federal legislation. It's very strong medicine.
Your Honor, whatever Congress thought of environmental law at the time, and in 1980 it determined that both federal and state law was inadequate. No one really realized the scope of the problem in 1980. Whatever it thought about state environmental law, Congress had no quarrel with state corporate law, with generally applicable corporate notions. In fact, quite the contrary. Congress specified in Section 9673A, it directed the courts in construing CERCLA not to construe CERCLA as displacing generally applicable corporate law concepts. And
But, counsel, one of the principal concerns at the time that CERCLA was passed was that the states simply weren't doing anything about it. I think Judge Higginbotham's point here is that to take a state I know well, in Kansas, there's a whole lot of successor and parent liability, and we don't have a lot of corporations moving to that state with their subsidiaries. Now, there are countervailing interests, among them economic development in the states, and maybe some of the states might change their laws or retain old laws in order to attract some subsidiary corporations.
Your Honor, no state would cut off its nose in order to spite its neighbor. If it had a rule...
Well, at the moment, economic development's not a small matter.
It is not, Your Honor, but Congress entrusted to the states in 1986 when it revised CERCLA, when Congress itself felt that the original federal attempt to cure the problem was inadequate. It understood that the only way in which the existing sites would be cleaned up would be if it created a federal-state partnership. In 1986, Congress estimated the cost of cleaning up all future environmental sites to be a minimum of $100 billion. And yet it funded, the Superfund at only $8.5 billion, because Congress understood that if sites were to be cleaned up, they would be cleaned up only if the brunt of the costs were in fact borne by the states. So it's the states here who have the most to lose. What Reed in effect is asking this court to do is to create federal common law in order to protect the citizens of Ames from their own laws. The citizens of Ames are the ones who will suffer here, and the citizens of Ames have chosen a rule which fairly reflects their concerns, their balance between having a clean environment and attracting business. And it is by no means an open question at all. In fact, we argue rather that these expansive rules would in no way advance the CERCLA's goals anyway. So this is not really even a clear case in which the court can simply say that it's clear that the expansive rules will do a better job of doing that. It's not at all clear. It's a difficult policy question, and it's precisely for that reason that the Congress should make that determination and not the courts. Now, it's also worthwhile reflecting on how radical Reed's request is here for yet another reason. That is, its reliance, in fact, I believe it's misreliance on Mississippi Band of Choctaw Indians versus Holyfield. What Reed cites that case for is a proposition that Congress normally prefers uniformity. What in fact this court did in Choctaw Indians is that it stated when there's an existing provision in a statute, the presumption is that that provision is defined uniformly. This court has never held in the federal common law context that the presumption is uniformity, quite the contrary. In Mississippi Band of Choctaw Indians involved the Child Indian Welfare Act of 1978, whose specific purpose was to strip from the states authority to decide Indian family law matters. In that context, this court had little difficulty in saying that Congress wanted a uniform federal rule. But what is interesting is that when this court created that rule, what this court did is it said that when we develop a uniform federal definition, we will turn to settled state traditional notions in doing so. We're not going to legislate out of whole cloth. And in fact, in that case, this court rejected Mississippi's rule of domicile precisely because it represented the exceptional or aberrational view. And what Reed is asking for here is for this court to adopt as a matter of federal common law and to give content to a federal rule, a rule as to parent liability which not a single state in this country accepts, and as to successor liability which only 8 states do. If any body is for policy reasons to so radically alter existing corporate law, it should be Congress, not the courts. At this very moment, Congress is considering no fewer than 11 bills to amend CERCLA, 4 of which deal specifically with standards of liability. This battle should be fought in Congress, not in the courts. Reed should not be permitted to obtain from this court by judicial fiat what it could not and cannot obtain from Congress through legislation. Thank you.
Mr. Chief Justice, and may it please the Court. My name is Jeffrey Dean, and I will be making 2 arguments. First, that the Court of Appeals was not required to defer to the EPA's definition of CERCLA liability precisely because the EPA simply has no authority to define liability under the statute. And second, that CERCLA, as a matter of law, does not impose liability on persons like Norport, based simply and exclusively upon Norport's commercial status as a parent corporation of a subsidiary that happened to have purchased assets from a generator that happened to have sent that waste to Reed's facility. Now first, as to the EPA, it is uncontroverted that the EPA has no authority to define liability under the statute. It is uncontroverted that the Congress never delegated formal rulemaking authority to the EPA, and that alone is sufficient to deny any claim to Chevron deference. This Court ruled last term in EEOC versus Aramco that absent a formal delegation of rulemaking authority, Chevron itself is completely inapplicable, that it just doesn't apply. But what makes this case even different from Aramco is that there isn't even adjudicating authority here. That it's one thing to say, like the EEOC's relationship to Title VII, where Congress says to the agency, you can make these legal determinations in the first instance, and then publishes guidelines to help employers out to let them know that when you are before this agency and we are adjudicating a complaint filed against you, this is what we're going to consider to be discrimination under the statute.
So you're saying basically all the EPA did was announce a potential litigating position, is that
That's
it?
exactly my position, Justice Souter. And this Court in 1988 in Bowen versus Georgetown University Hospital made it very clear, Justice Kennedy made it very clear, that this Court simply does not defer to mere litigating positions. Now, Reed bases the EPA's authority on Section 106 of the statute, where the EPA issues abatement orders to persons sitting on environmental time bombs, literally. Now that issues from the EPA's emergency response authority, where those orders issue wholly independent from determinations of liability, and only 60 days after someone complies with that order, they sue the United States in a district court of the United States, where the district court is determining liability for purposes of whether someone gets reimbursement from the Superfund or doesn't. Or the EPA can actually sue someone for reimbursement to the Superfund. Now that's just a matter of prosecutorial discretion. That's no different from when the Attorney General or a federal prosecutor decides that, well, we'll pursue this case, but we won't that. That we will settle with this defendant, but we will prosecute this one. That's prosecutorial discretion, and again, this Court doesn't defer to that. That would be tantamount to saying that when the Attorney General brings someone into a federal district court for the antitrust violations, or say under RICO, that we would defer to the Attorney General's interpretation of the criminal statute for purposes of deciding the criminal defendant's liability.
Well, counsel, that's all and well and good, but the line between litigation position, definition, filling the interstitial gaps, all of the terms of art are pretty hard lines to draw. There is a very good argument here that the EPA is entrusted with the broad purpose of cleaning up the mess in the environment. In doing that and in implementing Congress's purpose, the broadest possible liability is the most appropriate a way to read how one can clean up the environment fastest. The EPA is just doing what the federal regs are replete with, defining a term to try to implement a statutory purpose.
The trouble with that is that the reason why the federal regulations happen to be so replete with these definitions is that Congress has delegated quite a bit this kind of authority to define these kinds of terms. Here, however, there's been no delegation to the EPA to define any kind of term, to define liability terms, which is exactly the kind of case that was presented to this court last year in Ames Fruit versus Barrett. There was a question under the Federal Migrant and Seasonal Workers Protection Act. The Department of Labor had authority to issue standards and regulations, and this court made it very clear that authority to administer one section of a statute is not tantamount to authority to administer the whole. The court has never said that, and by the way, for good reason. Otherwise, the Coast Guard, for example, who issues the same kind of orders that the EPA issues under 106 when a spill occurs, say, in the Great Lakes, the Coast Guard now could issue rules of liability that then the unelected federal judges would rubber stamp, and now through the back door we've got law that Congress never intended to be made. This really is the kind of position that would work a total and complete circumvention of the political process.
Well, if it does, Congress can break into the circle, can't it?
Well, the trouble with that...
I mean, assuming we've got a risk of error here, why don't we err on the side of implementing circular and let Congress tell us we're wrong?
Well, there are two reasons for that. Well, actually, there are three. One is it would announce a rule that federal agencies absent authority to administer a particular statutory provision now can go ahead and do that, and then the federal courts will make that law through the back door. Secondly, Congress, we're seeing this problem right now, as a matter of fact, with Title VII, Title X and the decision Rust v. Sullivan, where Congress now has to have a supermajority to override the presidential veto of what is initially an administrative decision.
So when the Congress can't function under the constitutional arrangement, we should ride to the rescue?
I don't think so at all. I think Congress has functioned rather clearly in this context. In fact, Congress made it very clear who would and who would not be liable for response costs under CERCLA. Now, in this case, it's very simple. Either Norport arranged for the disposal of waste at Reed's facility, or it didn't. Now, we can interpret that very broadly. We can say that parent corporations can, in fact, be liable under the statute. But they're liable not because of their commercial status, parent qua parent, that's why we're liable, but rather because they actually had a hand in the fact of arranging for the disposal of waste through
But in that case, they're simply not being liable as a parent.
Exactly, exactly. When Congress wants to impose liability on parents and successors because they are parents and successors, Congress knows how to do that. Congress has done it under ERISA. Congress has done it under the Federal Mine Health and Safety Act. There, Congress is saying, in addition to the list of people that will be liable for their own conduct, there is now a list of people who are liable because of their commercial relationship to other people who are liable for their own conduct. That whole category of liability based simply on commercial relationship or commercial status, was omitted by Congress, and omitted deliberately. At least we have to have a rule of construction that says it was deliberate, because otherwise we would say that through silence alone, Congress can intend to wipe the slate clean.
Let's assume that, in fact, we shouldn't give no deference to the administrative interpretation of a corporation, so we're going to look at that issue afresh. What is the strongest point that you have that would push us to look to state law? What's the single most important factor that ought to lead us to look to the state law rather than to interpret the statute directly by federal common law?
The fact that there isn't a single example of where a person would be liable under CERCLA statutory provisions, even a very expansive reading of those provisions, that they would not be made liable under state law. You simply cannot escape liability because state law is providing the remedy. In other words, CERCLA as a statutory scheme is based on factual responsibility for the acts that make you liable and your control over the issues of hazardous waste. Now, the traditional rules of parent-successor liability operating in 42 states happen to be based exactly on that, control and factual responsibility.
But CERCLA doesn't say factual responsibility. In fact, it doesn't talk much about fault in the whole statute. So it is consistent with that lack of reference to fault that a broad interpretation drawn perhaps from a much broader than the traditional view would be appropriate.
In fact, CERCLA mentions the word responsibility 51 times throughout the statute, and the legislative history is very clear that it was meant to be factual responsibility. Now, it's true that CERCLA doesn't have a mens rea requirement or a negligence versus recklessness or that kind of requirement, but it is based very much on causation. Section 107A(3) is provides a defense to persons who were not involved in a contractual or agency relationship with a person who committed the act that made you liable under the act, which is to say that if we adopt Reed's rule, that defense gets wiped out of the statute. Secondly, there's a defense for an act of God, an act of war. These are clear principles of causation, at least. Yes, it's true, it's not based on fault, but it is based on causation. And this court has announced a rule of construction when we interpret cases that are based on strict liability, and that is that we're generally reluctant to go beyond the plain language of the statute precisely because the consequences are so harsh.
I'm not sure I understand your answer to my earlier question about what should inform our choice as to whether we should look to state law or continue in a common law course. Your response, as I understood it, was that, well, if you look to the state law, they uniformly would deny liability, therefore we should look to state law.
No, they would uniformly impose liability in every case that someone was even remotely connected to the actual act of generating waste or...
Well, that's just stating it the other way. They would uniformly, as you see it, not impose liability in this case. But why does that inform our choice?
Well, primarily because if we move beyond...
Unless you're presupposing that there is some policy of liability that's going to be frustrated.
That's absolutely correct. You
don't really mean that, do you?
To adopt the Reed's rule would frustrate a policy embedded in CERCLA? Yeah, I do agree with that.
You're saying then that there is a policy here that would be frustrated by non-liability?
Oh, by non-liability, excuse me, I didn't hear you. No, I don't think in this case there is a policy under CERCLA that would be frustrated by refusing to impose liability on Norport, primarily because it's no accident that this environmental release is being cleaned up with private funds. The Superfund certainly isn't going to be taxed by this. Reed, as a condition of operating its facilities, was required to prove to the EPA net working capital equal to 6 times the costs of this kind of catastrophe.
Yes, I understand, but we're sitting here and we say, okay, we've got to say what corporation means. Now, we can look over and look at what the states say it means, or X state or Y state, or all the states, add them up, get a median meaning, or we'll play some games or like that. Treat it like an Eighth Amendment question. We could...
That refers to continuing standards of civilization. I'm not sure we're close to that here.
Again, CERCLA doesn't impose, Norport does not contest the fact that it's a corporation, again. The only question in this case is whether we arranged for the disposal of waste at Reed's facility or whether we didn't. It's persons who arranged, it's corporations who arranged, it's associations who arranged, it's states or municipalities who arranged. Those are the operative terms. And we can interpret that very liberally, consistent with the fact that it's a remedial statute, consistent with the fact that it's enacted for the public health and safety, and then we can say, anytime someone had a hand, an actual hand, in some way, in the actual act that makes you liable under the statute, in this case, whether you arrange for the disposal of the waste, if Norport micromanaged the affairs of a subsidiary that had sent waste to Reed's facility, maybe that Norport could be liable there. But it is uncontroverted on this record, and Reed hasn't pled it in its complaint, that Norport had any hand whatsoever in the act that makes you liable under the statute. So that's why we are caused to adopt a rule that would make you liable, not because of what you did, but because of who you are. And that's not the statute that Congress wrote.
Or, as your colleagues would say, because of what you might have done.
But in this case, I'm not sure what we might have done, because the moment EPTEC, let's assume for the minute that Norport had total and absolute micromanagement.
But arguing that the parent's not the actor begs the question, doesn't it?
On these facts, let's assume for a second that Norport micromanaged the activities of EPTEC to the point where it manipulated everything. Now, even in this case, the moment it purchased property from Thompson, it stopped sending waste to Reed's facility and sent to another facility. So even in that...
So luckily, they just purchased the assets instead of merged or consolidated or continued the old business, which even under your reference to state law would have made them liable.
Right.
So they picked their corporate form so that they could get out of liability so they could frustrate the federal purpose.
No, well, there is a major distinction between asset sales and mergers in this case, or in the following example. When you have an asset sale, the only thing that happens is that illiquid assets go one way, cash goes the other, in which case the selling corporation is in the identical situation that it was prior to the sale to pay for its own environmental liabilities. Unlike a merger or consolidation where the surviving corporation takes a potential payor out of the system. Now, if Thompson then goes and wants to dissolve after that asset sale, then that is indistinguishable from a garden variety dissolution of a corporation. And certainly Congress didn't intend to prevent that. In fact, the Superfund was created for the purpose of the fact that Congress anticipated that that corporations would dissolve and wouldn't be around to pay for their environmental
Why wasn't it simply
liabilities.
created because Congress anticipated they might not have enough money?
Wait, I didn't hear your question.
Why wasn't the Superfund created on the assumption that Congress thought they might not have enough money, not because Congress wanted to facilitate their dissolution?
That private parties might have not enough money. Congress has already created a mechanism to deal with that problem, Justice Souter, and that is the fact that under the applicable regulations, the people who are in the very best position of control of hazardous waste treatment and disposal, and therefore of the potential of releases, are the owners and operators of the facilities. All we can do is make sure the lid on the drum is tight. They're the ones who treat the stuff. Now, under the applicable regulations, Reed is required to make financial assurances to the EPA equal to 6 times the estimated post-closure costs of its facility in the event of a release, which under the regulations includes leaks into groundwater.
Sure, that's when it goes into business. What happens isn't the object of the Superfund to anticipate the fact that at some point Reed may go belly up and not have 6 times anything.
Yeah,
isn't that the object of the Superfund?
That is one of the purposes of the Superfund.
It certainly isn't the object of the Superfund to facilitate dissolutions.
Not to facilitate, no, that's correct. But it certainly doesn't create a barrier to corporate dissolutions. Or if that's the problem in this case, then Reed should be suing Norport and asking this court to create a federal common law that would prevent dissolutions of corporations, not asking this court to create...
Well, that's next.
I see that my time is up. I'd just like to sum up with the following. At some point, we have to answer the following question. Do we respect the language employed by Congress and the categories Congress created, or do we not? Now, Congress never imposed this kind of liability, simply based on commercial status. It has done so in the past. It has basic language with which to do so. It can do so in the future. But if we impose liability upon Norport here, then we're announcing a rule of statutory construction that says through silence alone, Congress can abrogate the laws of 50 states in this union. And that rule would accord respect neither to the role of Congress in our constitutional system and our federal system, nor to the language that it ultimately employs. Thank you.
Mr. Patton, do you have rebuttal?
Yes, Your Honors, may it please the Court. I'd like to offer this Court a brief overview of the two parties' positions as we see it, and then briefly give an analysis of Respondent Norport's contentions. Your Honors, it's clear in this case that Norport unfortunately has this case backwards in terms of how does this court go about deciding whether Norport is liable, what the rule of successor and parent liability should be. The first question for this court is whether or not to defer to the EPA. That is clear from this court's doctrine in Chevron and through its progeny. However, Norport starts by arguing that this court has no authority to fashion rules. But again, that completely misunderstands the posture of this case. Now, Norport makes...
The posture of this case is pretty clear. We got to decide what the word corporation means. And it is a matter of ultimate liability under the statute. And isn't that a matter most distinctly, one, for the court to decide a matter of liability, and 2, to decide which body of law to apply.
No, Your Honor. The question is one of liability, but this court has said when it comes to interpreting a statute and what that statute means, this court will look first to the administrating agency because the agency is in a better position than this court to decide the intent of Congress.
We don't agree with that, and then we're to the second point. That we're not going to give deference to the administrative agency. Now what do we do?
Well, in that case, Your Honor, then we have argued that CERCLA requires expansive rules and that this court must enact a uniform rule.
What do we find that says that? We have the word corporation utilized. It has no meaning in federal law as such that we can easily reference. It has a defined meaning in state law. The most natural reading of that word is, as used, we look to state law.
Unfortunately, Your Honor, that's not true, and that is one of the mistakes that Norport has made, a fundamental mistake, that by assuming that by the fact that Congress did not put in a specific successor and parent liability part to CERCLA, that they didn't want any successors and parents liable. Both the district court, the Court of Appeals, and every single...
I'm talking about the choice of law question, not its outcome. And the question is whether corporation as used defines both one entity, both a parent and its sub and successors, et cetera. It could mean that in theory. What body of law do we look to? Do we make it up ourselves and decide that's what it means, or do we reference state law? Now, what informs our decision as between those two?
If state law were appropriate, Your Honor, it may inform your decision. But as this court said in Hearst versus NLRB publications, it's inappropriate for this court to somehow glean a general consensus of state law and make its decision based on that. That you must look to the purposes of CERCLA, the specific purposes of the statute. Let us recall that successor and parent liability, traditional rules, were not drafted... I'm sorry, Your Honor.
Congress knows how to define a corporation under state law for taxation purposes. Why shouldn't we assume that Congress knew that same state definition for this purpose when it didn't define?
Again, Your Honor, as we have pointed out, looking to other statutes is fruitless, and as Judge, who is now Justice Kennedy, as we noted, in Owner 2 versus U.S. EPA, in a very similar circumstance, implied a successor liability in the successor context, despite no direct authorization from Congress. Again, it would be improper for this court to glean state successor and parent rules when those rules were not drafted with hazardous waste, especially interstate hazardous waste, cleanup in mind. Now, when Norport says that our proposition is radical, let us not forget that CERCLA is an extremely radical statute. It imposes retroactive liability, strict liability, joint and several liability, things that had never been done before, and kicked the states out of the business of imposing state liability rules. So Norport merely misunderstands the whole scope of CERCLA. In their brief, they cite cases from a Depression-era ice manufacturing case, cases like Northwest Airlines and Texas Industries that deal with either Title VII implying rights of contribution, when in this case Reed is suing under an express right of contribution. They cite Kamen versus Kemper and Burks versus Lasker, which are shareholder derivative suits. Those cases have no application to this case. They cite barely a CERCLA case in their brief, Your Honor, or in their argument, and the only CERCLA case that they reference actually held that there should be a uniform rule of successor and parent corporation liability. So what this case comes down to generally, most specifically, Your Honors, is which side better understands what CERCLA is about, what the goals of CERCLA are about, and what the policy should be. And in this case, Reed has offered you a straightforward interpretation of what the EPA should do and what this court's role is. Let us not forget that I see that my time has expired.
You may finish your sentence.
That before Congress enacted a right of contribution under CERCLA, courts routinely implied it. Norport's argument that the courts have no authority is belied by the fact that Congress approved of the court's action to imply rights of contribution, then codified it in CERCLA. It shows they do not understand the statute. Thank you, Your Honors.
Thank you, Mr. Patten.
Everyone can take a seat. Thank you. The judges will be returning shortly with their decisions as to the best brief the best team overall, and the best oralist for tonight's argument. Before they come out, I'd just like to say one more time on behalf of both the Board of Student Advisors and the Dean's Office, I'd like to express our congratulations to the teams for the performance and for the arguments that we've seen here tonight. I think everyone will agree they were of a superior caliber, and I congratulate all of you on your efforts. And again, let me remind all of you that there will be a reception immediately following the decision over in the John Shipman Gray Room, which is on the second floor of Pound Hall, and everyone here is invited to that reception as well. Thank you. The judges will be right out.
All rise.
There are two kinds of appellate opinions, and you will see each kind illustrated by those who write for the court on which I am sitting these days. One is the opinion that begins with a lovely first paragraph that tells us what the issue in the case is, and then goes into part Roman numeral 1 of the opinion to tell us about the facts, and of course anyone who reads that says, who won? That is the sort of keep 'em guessing opinion. The other school of thought ends that first paragraph by telling us whether the respondents or the petitioners win the case, and the court this evening is unanimously of the second view, so we're not going to keep you guessing. Excuse me. I seem to be more nervous than the people who have been arguing tonight. Having told you how we rank in the three categories which we have been assigned to rank in, my colleagues then and I will separately make a few remarks. In terms of our ultimate judgments, we give the award for the best brief to the respondents team. We find I say best brief, there were three, better brief, maybe I should say better set, to the respondent. As to the best oralists this evening, we give the nod to Mr. Patton, the petitioner's team. With respect to the best overall, I think you will all, when you hear the decision, agree with us that it is at least a substantially realistic judgment, because we have a divided court on that. Justice Tacha and I find the respondents' overall position the strongest, developed through their brief and their argument. Justice Higginbotham would give the nod to the petitioner's side. So I think maybe before I turn the spotlight to my two colleagues, I will just say that divided vote on the overall ranking underscores something that all three of us wanted to make sure we said, and that my colleagues authorized me to say before we get down to slightly more specific cases this evening. And that is simply to appreciate, to emphasize rather, our appreciation of the richness of what we have heard. We are all sitting daily on courts in which the written and the oral fare can reasonably be expected to be extraordinarily high. And sort of by all the rules of practice in the judicial marketplaces that we operate in, it is high, but it's not this high. I say that just to emphasize the great difficulty that we have in these kinds of rankings. I mean, we have to make them. That's our job. But they are extraordinarily difficult to make. I thought several times during the arguments this evening of something that Chief Justice Rehnquist has been known to do, and that is to interrupt someone who is arguing and say, so-and-so, slow down. And he does that not so much from some innate sense of rhythm, but because there is... There are limits to what can be assimilated. I was not, as I said, tempted to do it this evening, but I am tempted to, and have given way to the temptation to saying that the thought crossed my mind simply because the sort of richness on a per word basis of what we heard by way of oral argument this evening is simply not only outstandingly good, but something that we just rarely see. And for the three of us, it was a great deal to take in the time that we had, and that is, I hope, a great compliment to everyone here. With that, let me defer rather to Justice Tacha for some comments from her.
Well, I simply echo the fine job that you all did and the fine job that's reflected from the teams in the briefs. Although 4 people stood before us, many more through all the rounds of this competition did a great job. And for these to have emerged, it tells me there were a lot of people in this competition who did a really outstanding job. So congratulations to all of you, though you might not have been the 4 arguing. I also extend my congratulations to the drafters of the problem. I have done moot courts in many places and think that this is one, not only that, as you can tell, is highly relevant to things that are occurring in the courts. Indeed, we tried to be very careful and not to express any views on the problem because it is a very timely one and one that involves some very important questions for our whole nation. So my congratulations. I will limit my comments just to some very quick stylistic comments. All 4 of you in the oral argument had a remarkably good appellate argument style. You will see as you move into practice that there are 2 quite different styles for oral argument. One is, of course, the trial style that goes to a jury, and it's always very tempting to make that same kind of an argument to an appellate bench. Quite the contrary. You were able to establish a rapport with this bench that I thought was quite good. Each of you was good at that. Be comfortable, be as relaxed as possible under the circumstances. Try to listen very carefully to the questions. The questions will reveal a great deal about what's on the judge's mind. You did that and did that very well. Always be ready for the practical question. One of you got the question, well, how are we going to do it? Well, that's the most obvious practical question, but we get so involved in an oral argument in the legal questions that all of a sudden sort of the big practical one sneaks up on us. So maintain that very nice informal style. Remember that the purpose of an appellate argument is for you to inform the bench and the bench to ask the questions that are on their minds. You did a very, very nice job, all of you, with that. I would only close by saying to all of you, faculty, students, families, friends, you have all done honor to a fine law school tonight, and I was proud to be here.
Thank you. Judge Higginbotham?
I congratulate each of you for a fine job. And to you, Mr. Patton, I will say that you should relish this moment, because only in the wee hours of the morning in your wildest fantasies will you conclude an argument to have the audience rise in applause. The part of the country that I grew up in and practiced law in, we practiced law largely in the trial courts by a rule of parable. And maybe I can make my point, that brief points with you this evening in using that technique. The point I want to make with you is that today, and certainly, and perhaps always, but certainly today, the art of oral advocacy is the art of responding to questions. It is the technique of being able to grasp the question, to respond to it directly, and to do so in a way that persuades and turns it back, all the while in some way maintaining in your back of your head this outline, or this rough outline that you had about what you wanted to say. There are two types of questions. One question is when the judge or justice wants information, and you'll be able to spot that. But there's another kind of question, and that's the question in which a judge or a justice is really speaking to a colleague. And you can use your own senses about how to respond to those two, but I can tell you something that occurred in our court that may help you a bit in spotting that difference. In our West Courtroom in New Orleans, Louisiana, there was a case being argued, and it was presided over by Chief Judge John R. Brown, for our Chief Judge for many years. And seated to his left was John Minor Wisdom, and to his right was another distinguished judge, now our Chief Judge, Charles Clark. And a lawyer from Mississippi was arguing a case. And as the lawyer got to his feet, Judge Wisdom immediately hit him with a series of questions. He said, "Counsel, you have argued the Smith case, and you'll have to concede, will you not, sir, that if Smith said this, then it follows that we must reach this conclusion?" The lawyer looked at him and said, "Well, yes, sir, I guess so." And Clark came back from the other side, "Well, wait a minute, counsel. On the other hand, if we look at footnote 6 in the Smith case, we'll see that that was qualified. And if we assume that premise, then we'll reach that conclusion." "Well, yes, sir, that's right." Wisdom came back the other way, said, "Yes, but then later on in the Adams case, and that whole line of cases, we said this, didn't we?" "Well, yes, sir, we did." And so you can't maintain that proposition then, can you? "Well, no, sir, I guess I can." Judge Clark said, "Well, no, wait a minute, wait a minute, counsel." And so he came back and argued another one. He said, "That's right." So finally, at this point, Judge Wisdom hit him one more time, and he said, with the same kind of question, and he scratched his head, and he looked down, and this time Judge Clark had quit playing the game, was looking down at the bench, and he looked up at Judge Clark and said, well, what do we say to that?" So sometimes you see the questions really are somewhat rhetorical in form, and you can judge those. But they're very difficult to respond to, and I'll tell you one other brief story that will illustrate that. Some years ago, and when I was on the other side of the bench, I had the occasion to argue a case, and I was sitting as a special prosecutor and trying to defend an appointment. And it was a highly public case, and there was a great deal of press attention to it, and we were the last case to argue. And we were arguing before a distinguished federal panel in the Court of Appeals, trying to convince this court that the appointment did not violate separation of powers principles. The case immediately before us, the young lawyer who was arguing the case had never argued before. He was in the appellate section of the Tax Division, Department of Justice, and he had been sent to New Orleans to argue his first case, and he was told there'd be no one in the courtroom to hear this tax case. And he got there, and they were hanging from the rafters. The national press was there, waiting for this last case, which had some political interest in it. Well, as he went to the bench and he argued the case, only Judge Wisdom was asking him any questions, and he was holding on to the lectern and his knuckles were white. We were seated behind him watching this, and he was hit with question after question after question. And finally, mercifully, the light came on, and he retreated. But as he retreated, Judge Brown looked at him and said, "Counsel, this is your first time to come to our court." And he said, "Yes, it is." And then summoning up courage and gaining his strength, he said, "Yes, sir, it is." And said, "You know, I was told that when I came down here, this was a, quote, hot bench, and you ask a lot of questions, and you do ask a lot of questions, but I found it invigorating." He said, "Well, thank you very much, counsel." And so he felt very confident. He started to back away again. He said, "Counsel." And he said, "Yes, sir." And he came back to the bench. And he said, "Did you ever hear the story about Justice Douglas?" And he said, "No, sir." And there was a reporter next to me. That's why the pad come out. He said, I didn't know that judges told stories. And I said, "This one does." And he said, "Well," they said, "young man," he said, "you see, Justice Douglas was in a taxicab in Washington, and he was racing down through Washington, and he passed the archives building, and he looked out there, and it said the past is prologue." And he tapped the cabbie on the shoulder, and he said, "What does that mean?" The cabbie, without hesitating, said, "That means you ain't seen nothing yet." So if you'll just send out over a young man, don't leave, and I'm going to call the next case. And he meant what he said. So questions are both that's the art form. It's also the form of terror. And I thought that each of you were well on your way toward mastering that skill, and I congratulate each of you and all the other participants as well. And finally, I also joined Judge Tacha in her comments about the problem. I thought it was extremely well done and enabled you to set up this fine argument.
Well, I have a little wrap up. I don't have a Justice Douglas story, or rather I do, but I'm not going to tell it. I don't want to preface what I say by, or would not want to preface what I say by suggesting that we sat out there and in our chambers and said to each other, somebody's got to say something critical. But in a sense, I am going to, although it does not reflect specifically on in fact, either team to the relative detriment of the other. I wanted to say a word for a second about the kind of the sense of overview, overview of what the appellate process involves, and an overview of kind of the ultimate sense of strategy that is always either adopted or perhaps in rare cases rejected for extraordinarily good reasons in an appellate argument. The thing, and I think that we all feel this is worth mentioning tonight because it's a story about the sort of the difference between the forest and the trees, really, and maybe it's a good time to make comments of this sort because, as we've all said in various ways, the trees were so tall and strong and plentiful tonight. The arguments and the briefs were so rich. One of the dangers, I think, that comes with such a degree of erudition and detail, as we have seen tonight, is, of course, the danger of losing the forest for the trees. Hence a word about sort of the ultimate strategic basis for appellate advocacy. In any case, the appellant, or as we call them here, the petitioners, are presumably coming into court trying to persuade the court that somebody has done something wrong. Occasionally the court from which the appellant or the petitioner comes has done something so obviously wrong that that's a lead pipe cinch. But it's not a lead pipe cinch in very many cases. And the thing to bear in mind as an overview of what goes on in this process is that assuming a sound bench below, any appellate arguer and any petitioner's appellate counsel should be facing, and usually is facing, some kind of an uphill fight. There is a burden to persuade of error. That being the case, the easiest way, theoretically, to win any such argument is to try to make it very easy for the court to say, I can correct this error in the least disturbing way to the body of the law. If you want to win a petitioner's argument, as a general rule, tell the court to the extent that you can, persuade the court to the extent that you have a reasoned basis for doing so, that it doesn't take very much to see it your way. You want the court to see the position that you want it to take as the result of taking kind of a baby step, not a giant leap. By the same token, if you're on the other side of the case, once again, not for the sake of just indulging in theoretical hyperbole, but if you can make an argument to this effect, you want the court to see the step that it's being asked to take as being a gigantic step. As being an enormous stride, fraught with difficulty, just portending implications that are in themselves horrendous and that can't even be assessed at this point. You want to make it hard for the court to disturb the status quo with which everyone comes in. And in that respect, I think that each side might have come on a little bit tougher than it did tonight. I couldn't help but think as I began to read the petitioner's brief in this case that they were quite willing to tell us that what they wanted us to do was to impose a most comprehensive scheme of liability. They wanted us, in effect, they were telling us that they wanted us to adopt sort of the broadest possible rule of liability, at least within the kind of practical universe within which they operated. Now, to be sure, there is something to that. But they let us get into the case thinking that they were asking us to take a very big bite at the law. And I think perhaps if nothing else, their rhetoric perhaps might have served them better if they had not, as it were, confessed at the beginning that they were asking us to take such a gigantic step. On the other side of the coin, although I think it is perfectly true that the respondents in this case did in many detailed ways point out the difficulties, of course, of the petitioner's argument, there was a kind of global sense which perhaps the respondents lacked. I think back to one of the remarks that the petitioner's counsel made this evening, something to the effect that by holding their way, we would merely be affecting the relationship between a couple of parties here, a couple of entities. And although I think, although indeed nobody interrupted counsel at that point, that was really kind of an extraordinary statement. Because the truth is, there is no one, well, I was going to say there's no one sitting at this bench. There's certainly no one speaking at this microphone at this moment who has the remotest degree of confidence in where the sort of spreading concentric circles of economic consequences would end if we were indeed to take the as broad a position as the petitioners might like us to take. It may well be true that in the real world the petitioners would have had their way. The real world of courts that were going to rule on the merits, but be that as it may, I think it would have been very fair here to make the argument that if anyone is going to play an economic sorcerer's apprentice, it is the sort of the elected side of the government that ought to be taking those risks for society, because we couldn't I simply couldn't see what the ultimate economic consequences might be of seeing it in the petitioner's way. So I think when I said I might say something critical but do it in a rather even-handed way, I meant what I said. I think perhaps I think it was true that the petitioners did not make their position as ostensibly limited as they might have done. At least the rhetoric of their brief did not do so. And the respondents did not sort of expand the risk of judicial error to quite the global scope that I think it would have been fair to argue. That being said, I guess I will say with T.S. Eliot that in my beginning is my end, and I will go back to what I started by saying a few moments ago, and that was just a word of appreciation for the richness of what was said here tonight. And I will, with the permission of my colleagues, just add a further personal note, and it is a note about what the individuals arguing before us this evening should expect in their future. Because as I was coming up on the plane this afternoon, I was doing a little historical rumination of my own, and I realized that if I've got the arithmetic right, it has been 27 years since I sat within the jurisdiction of Ames. And not only is this perhaps good luck for the next 26 years of Harvard Law School classes, but I thought back to the argument that I last heard. And I'm happy to tell you that for whatever reason, one of the lawyers who was arguing before me that night is now the Dean of Columbia Law School. So I predict an extraordinarily bright academic future for one of you. We could... We could not make up our minds which one. So we shall wait and see, and we will remember tonight not only with great appreciation but great pleasure.